If you are someone who has struggled to find work after leaving a company, this video is for you. Also, if you are someone who works in a position that places you in charge of hiring employees, this video can also be helpful to avoid compromising your company's reputation. There are some employers who are not content to just terminate an employee, but some take actions to prevent former employees from finding work elsewhere. Trying to prevent someone from working again is blacklisting, which is an illegal activity that may be punishable as a crime, civil offense, or both. Employers and recruiters don't openly admit to maintaining blacklists, but the practice is unfortunately common. The first published reference to blacklisting of an employee date back from 1774. This became a significant employment issue in American mining towns where blacklisting could mean a complete loss of livelihood for workers who went on strike. In 1901, a report of the Industrial Commission stated, there was no doubt in the minds of working men of the existence of a blacklisting system, though it was practically impossible to obtain evidence of it. It cited a news report that in 1895, a former conductor on the Atlantic and Pacific Railroad committed suicide, having been out of work ever since the strike. Wherever he went, the blacklist was ahead of him. In 1933, the National Industrial Recovery Act gave employees the right to organize and bargain collectively. Numerous strikes occurred until blacklisting was declared unconstitutional by the Supreme Court in 1935. Although the National Labor Relations Act of 1935 outlawed punitive blacklists against employees who supported trade unions or criticized their employers, the practice remained common. Indication of blacklisting. Not being able to secure employment immediately is not an indication that you have been blacklisted. However, a strong signal of possible blacklisting would be a series of situations in which potential new employers seem to be on the verge of hiring you, then suddenly lose interest. This indicates that when a prospective employer checks your references just before hiring you, the former employer is tipped off to where you have applied for work and has most likely given you an unfavorable reference, indicating that you are an undesirable employee, generally based on superficial or subjective opinions. Why do employers blacklist? Employers and recruiting agencies blacklist ex-employees or potential candidates for some of the following reasons: incompetence, insubordination, skipping job interviews, doubting skills or competencies, political or religious views, or simply because they don't like them. Although these reasons may seem justifiable to the employer, candidates or ex-employees still have the right to find employment elsewhere and should not be blocked for any reason. What to do if you suspect that you've been blacklisted. Contact your previous employer and request a meeting to discuss your job search issues and your concerns about the reference the employer is giving you. Ask for helpful feedback from the previous employer about what went wrong and what could be done to correct the mistake. Be open to the advice or suggestion of the previous employer, but make sure their views are not subjective or unreasonable. Make sure you stand up for your rights if you're being discriminated against. Do realize that no matter why they chose to blacklist you, you still have rights to seek work elsewhere. Be polite and professional with your existing as well as the former employer, and don't burn your bridges. What can employers do to prevent blacklisting? It is advisable to base the reference you are giving on the performance, professionalism, and the tasks that were given to the previous employee. It is best to adhere to specific guidelines to prevent any potential lawsuits of defamation or to be accused of preventing a previous employee from finding work. Things to confirm or verify: the candidate's employment, job title, pay, the period of employment, and responsibilities. If asked if they are eligible for rehire, answer yes or no. If asked why, it should be based on truth and not subjective opinions or prejudices. Answer how the employee got along with the coworkers and management. Avoid discussing anything that can be viewed as discriminatory, such as race, religion, appearances, etc. Employment reference letters. It is not uncommon for employers to provide reference letters to an exiting employee. Sometimes this is done at the request of the employee, other times it's offered without asking. An employment reference letter is a document in which the writer, the previous employer, assesses the qualities, characteristics, and capabilities of the person being recommended in terms of the individual's ability to perform a particular task or function. The information within the letter summarizes details of the title, dates of employment, and the general work that was performed. Once the letter of recommendation has been signed and given to the previous employee, it should be understood that the written information will be upheld if a potential employer contacts him in the future. Copies of the letter of recommendation should be placed in the previous employee's file and used as a reference guide on what to say if someone calls to inquire about the employment history of the previous employee. So the letter of recommendation assesses the qualities, characteristics, and capabilities of the previous employee. It provides details of the employee's title, date of employment, and general work that was performed. If the previous employee's work was outstanding, it is customary to state this in the reference letter. Keep a copy of the signed reference letter in the exiting employee's file for future reference if a potential employer contacts the company in the future. In order to avoid confusion, it is best for companies to frequently meet with their employees to provide feedback on their performance. A strong company encourages open communication and generally have policies to protect the company and the rights of the employees. It is a good practice to evaluate the employee's performance during the course of their work history. Take time to discuss the expectations of each employee and to encourage their strengths and provide guidance on any weaknesses to improve. This gives a clear understanding of where the employee stands so there are no misunderstandings in the future, during their employment, or after they leave the company. Good employment practices. Develop policies to regularly evaluate the performance of each employee fairly. This can be done monthly or quarterly. Base the review on functions that are being performed and their conduct. Avoid evaluations based on outside influences such as gossip or prejudices. Do not use issues relating to religion, race, politics, marital status, or any other discriminatory issue to influence the evaluation of an employee. By having strong policies and procedures in place, the employee and the employer will both know where they stand and will avoid any misunderstandings while on the job or after leaving the company. With these systems in place, blacklisting can be avoided. I have compiled a list of blacklisting laws on the books in the United States. If your state is not listed, there may still be a state administrative regulation or local ordinance that may control issues relating to blacklisting. Call your state labor department for more information. Alabama, maintaining a blacklist, notifying others that an employee has been blacklisted. Using any other similar means to prevent a person from obtaining employment. Arizona, the knowing exchange, solicitation, or gift of a blacklist. A blacklist is any understanding or agreement that communicates a name or list of names or descriptions between two or more employers, supervisors, or managers in order to prevent an employee from engaging in a useful occupation. A blacklist can be spoken, written, printed, or implied. Arkansas, writing, printing, publishing, or circulating false statements in order to get someone fired or prevent someone from obtaining employment. Publishing that someone is a member of a secret organization in order to prevent that person from securing employment. California, preventing or attempting to prevent a former employee from getting work through misrepresentation. Knowingly permitting or failing to take responsible steps to prevent blacklisting. In a statement about why an employee was discharged or left employment, implying something other than what was explicitly said, or providing information that was not requested. Colorado, publishing or maintaining a blacklist, conspiring or contriving to prevent a discharged employee from securing other employment. Notifying another employer that a former employee has been blacklisted. Any employer that provides written information to a prospective employer about a current or former employee shall, upon that employee's request, send a copy to the employee's last known address. The subject of such a reference may also obtain a copy by appearing at the employer or former employer's place of business during normal business hours. Connecticut, blacklisting, publishing, or causing to be published the name of any employee with the intent and for the purpose of preventing that person's engaging in or securing other employment. Conspiring or contriving to prevent an employee from procuring other employment. Florida, agreeing or conspiring with another person or persons in order to get someone fired or prevent someone from obtaining employment. Making threats, whether verbal, written, or in print, against the life, property, or business of another in order to get someone fired or prevent the procurement of work. Hawaii, making, circulating, or causing the circulation of a blacklist. Idaho, making a blacklist, notifying another employer that a current or former employee has been blacklisted. Indiana, using any means to prevent a discharged employee from obtaining employment. Upon written request, prospective employers shall provide job applicant with copies of any written communication from the applicant's current or former employers that may affect the possibility of employment. Iowa, preventing or trying to prevent, either verbally or in writing, a discharged employee from obtaining other employment. Authorizing or permitting blacklisting, making false statements about an employee's honesty. If a company, partnership, or corporation authorizes or allows blacklisting of a former employee, it shall be liable for treble damages. Kansas, using words, signs, or any kind of writing to prevent or attempt to prevent a discharged employee from obtaining other employment. Any person, firm, or corporation found guilty of blacklisting shall be liable to the injured employee for treble damages and attorney fees. Maine, maintaining or being party to a blacklist, either alone or in combination with others. Preventing or attempting to prevent an employee from entering, leaving, or remaining in employment by threats of injury, intimidation, or force. Preventing or attempting to prevent anyone from obtaining employment by means of a blacklist. Any person who violates this law can be found guilty regardless of whether he or she intended to cause the employee harm. Massachusetts, using intimidation or force to prevent or attempt to prevent someone from obtaining or continuing in employment. Minnesota, combining or conferring with another or other employers to interfere with or prevent a person from obtaining employment, using threats, promises, blacklist, or any other means to get someone fired. Blacklisting any discharged employee. Verbally or in writing attempting to prevent a former employee from obtaining employment elsewhere. Montana, refusing to respond to a former employee's demand for a written statement of the reasons for discharge while providing a statement of those reasons to another person. Blacklisting by word or writing of any kind or authorizing or allowing a company's agents to blacklist. Attempting by writing, verbal, or any other means to prevent a discharged or former employee from obtaining employment elsewhere. Nevada, for any employer or employer's representative blacklisting or causing an employee to be blacklisted, publishing any employee's name or causing it to be published with the intent to prevent that person from getting work, conspiring or contriving in any manner to prevent discharged employees from procuring other work. New Mexico, for an employer or employer's agent, preventing or attempting to prevent a former employee from obtaining other employment. New York, making, maintaining, distributing, or circulating a blacklist to prevent an employee from obtaining or continuing employment because employee exercised rights to organize, unionize, or bargain collectively. Informing any person of an individual's membership in a labor organization or exercise of protected labor rights in order to prevent them from obtaining or retaining employment. North Carolina, preventing or attempting to prevent by word or written of any kind a discharged employee from obtaining other employment. North Dakota, maliciously interfering or in any way hindering a person from obtaining or continuing other employment. Oklahoma, blacklisting or causing an employee to be blacklisted, publishing or causing employee's name to be published with the intent to prevent the employee from getting work. Requiring employee to write a letter of resignation with the intent to prevent or hinder other employment. Oregon, Blacklisting or causing any discharged employee to be blacklisted, publishing or causing the name of any discharged employee to be published with the intent to prevent the employee from getting or keeping work. Conspiring or scheming by correspondence or any other means to prevent a discharged employee from obtaining employment. Rhode Island, making, maintaining, distributing, or circulating a blacklist to prevent an employee from obtaining or continuing in employment because employee exercised rights to organize, unionize, or bargain collectively. Informing any person of an individual's membership in a labor organization or exercise of protected labor rights in order to prevent them from obtaining or retaining employment. Texas, blacklisting or causing to be blacklisted. Preventing or attempting to prevent by word, printing, sign, list, or other means, directly or indirectly, a former employee from obtaining other work. Communicating directly or indirectly information about an applicant without giving the applicant a copy of the communication and the names and addresses of those to whom it was made, within 10 days of demand. Receiving a request, notice, or communication preventing or calculated to prevent the employment of an applicant without giving a copy of the communication to the applicant and the names and addresses of those to whom it was made within 10 days of demand. Utah, blacklisting or causing any former employee to be blacklisted or publishing or causing the name of any former employee to be published with the intent or purpose of preventing the employee from obtaining or retaining similar employment. Exchanging blacklists with or among railroads, corporations, associations, or persons. Maliciously interfering with any person's obtaining or continuing employment with another employer. Virginia, willfully and maliciously preventing or attempting to prevent, verbally or in writing, directly or indirectly, a former employee from obtaining other employment. Washington, willfully and maliciously sending, delivering, making, or causing to be made any document, signed, unsigned, or signed with a fictitious name, mark, or any other sign, publishing or causing to be published any statement in order to prevent someone from obtaining employment in Washington or elsewhere. Willfully and maliciously blacklisting or causing a person to be blacklisted by writing, printing, or publishing their name or mark or sign representing their name in a paper, pamphlet, circular, or book, along with a statement about that person for the purpose of preventing employment. Willfully and maliciously publishing or causing to be published that a person is a member of a secret organization in order to prevent them from obtaining employment. Willfully and maliciously making or issuing any statement or paper in order to influence or prejudice the mind of an employer against a person seeking employment or to cause someone to be discharged. Wisconsin, any two or more employers joining together to prevent any person seeking employment from obtaining employment. Cause the discharge of an employee by threats, promises, circulating blacklists, or causing blacklists to be circulated. Prevent or attempt to prevent by blacklist or any other means a former employee by obtaining other employment. Authorize or allow any other agents to blacklist a former employee. Giving any statement of the reasons for an employee's discharge with the intent to blacklist, hinder, or prevent the discharged employee from obtaining other work. Remember, when a former employer attempts to prevent or exclude someone from subsequent employment, it is a serious matter because this barbaric act marks individuals for exclusion, which can lead to loss of reputation, homelessness, or even suicide. If you are in charge of employees, please take your position seriously and do what you can to not participate in this illegal activity. If you have blacklisted someone in the past, correct your mistake and do what is fair. As for those seeking employment, you have a responsibility to yourself and your family to keep trying to find work. Stay strong and don't give up. I hope this video has been helpful. Please feel free to provide any feedback that you feel will be useful in the future for more of my videos. Thank you for watching.